Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which focuses on providing you with some information necessary to ensure policy and regulatory compliance for employees working remotely these days. Joining us today to tackle what we consider a complex topic are two members of our Labor and Employment Law Practice Group, Laura Dinan from our office in Petoskey, Michigan, and John Gillum from our Bloomfield Hills office. Before we get started, I always like to take a few moments to provide some background about today's speakers and about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our employment law practice group includes more than 20 attorneys who work in the traditional areas of labor law, human resources consulting, and investigations, as well as all aspects of employment litigation. Our webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute and 1.25 professional development credits through SHRM. Following today's program, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need it, just simply discard that certificate. So let me just take another moment or two to introduce our presenters today. Laura Dinan has over 30 years of experience advising employers on all aspects of workplace-related issues. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Her expertise includes consulting on employment law issues, administrative hearings, traditional labor, and even litigation. She's a current board member and a past president and past secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. John Gilliam has more than 10 years of litigation experience and focuses his practice on representing and advising employers across various industries. His litigation expertise includes a range of matters from discrimination and harassment to wrongful termination and incidents of workplace violence. He also advises his clients on a host of employment issues, including corporate policies and procedures, contract negotiations, and consultation on human resource actions. Now, just a couple quick housekeeping notes, and we will get started. For the Q&A portion of our webinar, we're going to use our questions widget, which is on your dashboard. So I would invite you to please take a look for that and make sure you're familiar with how that works. And we invite you to ask questions throughout the program. At the end of the presentation, we'll try to answer as many questions as possible. And I always like to add one caveat to this portion of my remarks. We ask that you keep your questions to somewhat of a general nature. We certainly don't want to delve into specifics about your particular workplace to protect yourself and your workplace from any problems on that front. So we want to keep it kind of generic for the audience. Finally, I want to mention that today's session is being recorded, and that recording will be available on our event page on Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share a link and direct your other colleagues who couldn't maybe join us to that page. We also actually post these videos to YouTube, so you can check out our video catalog there as well. Thanks again for attending today's webinar. Now let's get started. Laura, I believe you are leading off today's presentation, so please take it away. Laura, I don't know if you're on mute. You might want to check, make sure you're off of mute there. John, can you hear me on this? I'm wondering if we have a bit of an audio issue. Can you chime in?
I can hear you, John. Yeah,
Okay.
I can hear you. And while Laura's getting connected, I can provide just a little bit of an introduction.
Great.
As John said, my name is John Gillum. I'm in the firm's Bloomfield Hills office, and kind of what really precipitated this webinar for us. Oh, there's Laura. Great.
Sorry, I don't know what happened. I was not on mute, but Thanks, John, for stepping in. We get a lot of questions about working remote. I think everybody here has experienced at least some remote work in their workforce, and many of my clients and the firm's clients are struggling with how to decide going forward if they're going to allow remote work, and if they do allow remote work, who gets to do it, and how do you manage it? So we thought putting some of these concerns that we've heard and trying to give you practical tips for managing remote work versus in-office work and some hybrid combination of both might be helpful. So that's where we're coming from today. It's hard to believe, but 2 years ago this week is when the world shut down, and we're just really starting to see businesses ramp up in terms of bringing people back into the office as we now enter the endemic stage. So as I kind of referenced, I think that, John, you can go to the first slide, please. The new normal is going to be deciding between people in the office versus remotely or some hybrid. A lot of employers seem to be really flexible, at least right now in the start of trying to ramp back up by allowing a 2/3 day split of home and office or some combination thereof. According to a recent study by Deloitte, 2 out of 3 employers said they would allow more flexibility for remote work after the pandemic ends, and 79% of those respondents reported that at least 75% of their workforce was able to work remotely during the pandemic. And of those employees who worked remotely, 2/3 felt that the company did a good job of managing and supporting them remotely, and 2/3 said they were going to consider remote going forward. We're all aware that unemployment is very low, that it's very difficult to hire new employees. They have their choice of jobs because it seems like every employer out there is hiring. And so if you are a workplace that is not flexible on remote work, you may have a much harder time attracting employees because the workforce now is looking for flexibility and looking for at least a hybrid, if not ability to work remotely full time. So if you're out there competing for employees, you need to consider that. And there are benefits to providing flexibility in addition to attracting employees. Many employees place their ability to work remotely and flexibility above their expectations for pay. They still want to be well paid, but that is a very important factor to them. So what pitfalls do you need to identify and avoid? We're going to try to answer that as we go through this seminar. But first, next slide, John, we're going to just do a quick update on the current status of the government guidelines and requirements regarding vaccines. So as everybody knows, January 13th, the Supreme Court blocked the Biden administration private employer vaccine mandate for employers of 100 or more employees. And they blocked it pending a decision from the Sixth Circuit. The Biden administration ended up withdrawing the vaccine mandate on January 26th and then dismissed the Sixth Circuit case. So that rule is gone. However, some states are requiring vaccinations for certain private employees and state employees, and other states are adopting laws to prohibit or limit workplace vaccine mandates. Michigan is doing neither, but if you're in a state other than Michigan, you want to check that out. In general, employers on their own can choose to mandate vaccines, but you have to allow people to apply for medical exemptions and religious exemptions and give those serious consideration. But as a rule, you can adopt vaccine mandates. Most employers that I've had contact with don't want to do it, going back to the issue of attracting employees. They're afraid that if they force it on their employees, not only will it be difficult to get new employees, but their current employees can go next door and get a job at the next employer who doesn't mandate it. So we're not seeing a lot of that, at least up here. The vaccine mandate for federal contractors, if any of you are subject to those rules, that rule is not gone, but it's currently on hold due to various court injunctions and waiting the outcome of those cases to work through the court system. The CMS mandate that healthcare facilities subject to Medicare and Medicaid have to have all employees vaccinated unless they have a medical or religious exemption granted is in place. So if you're a healthcare facility subject to Medicare and Medicaid, you are required to mandate vaccines for people in your facilities. In addition, if you run a Head Start program, the Head Start mandate is in place. So any employees, visitors to Head Start are required to be vaccinated. So just be aware of those requirements. OSHA has withdrawn the emergency temporary standard, but did so indicating that instead of going the emergency route, they were going to put out a permanent healthcare standard, and that may include mandatory vaccines, but we don't know what they're going to put into it or when that will be coming. So right now, no mandate. Next slide, please, John. Thanks. So along with vaccine mandates, the CDC guidance on quarantine and isolation is probably of interest to some of you. This has evolved and changed significantly. As most or all of you are probably aware, the CDC and the Michigan Department of Health and Human Services, as well as local health departments, are all using this community level of infection rate to determine what recommendations are out there and you need to follow. Currently, most of the state of Michigan is in the low community level, which means you really don't have to take precautions unless you have vulnerable people that you're in contact with, or you have been exposed or actually have COVID. So masking is still recommended indoors, but in the low areas, it's pretty much not followed. Flip to the next slide, please, John. So the current CDC guideline is if you're exposed but you're not up to date on vaccinations, you have to quarantine for 5 days and wear a mask, and then get tested 5 or more days after you were exposed, because COVID is not showing up until 3 to 5 days after exposure. So if you get tested before 5 days, it may not be accurate. And after 5 days, you can go back to work or break your quarantine, but watch for symptoms for another 5 days. So a full 10 days, watch for symptoms to break out and take precautions until the 10th day. And we've put the actual picture of the CDC website up there for you to be able to refer to. John, can you go to the next slide, please? So if you've been exposed, don't have symptoms, and you're up to date on your vaccination, you do not have to quarantine. You need to watch for symptoms for 10 days and take precautions until 10 days are up, but no quarantine. Next slide, please, John. If you've been exposed, but you've actually had a confirmed case of COVID within the past 90 days, again, you don't have to quarantine unless you have symptoms, and you need to watch for the symptoms for 10 days and take precautions for 10 days. If you actually come down with COVID, you still need to isolate until 24 hours past the symptoms abating. And those guidelines are also on the CDC website. John, I think you are going to take the next topic from here.
Thanks, Laura. So, another issue that we probably did not have on the forefront of our minds when this pandemic started, but which, we think is now going to need to be considered by employers when they're looking at these hybrid work arrangements, are the tax considerations or tax implications, particularly with an ever-growing remote workforce. This could call into play some tax situations that certainly are beyond my scope of expertise, but because it does impact employers and HR professionals, we thought it would be worthwhile to include in these slides. So just to give a brief example, I was just down visiting my in-laws in Florida, and one of their neighbors is not a retired individual, but is from the Northeast and has decided he's going to go ahead and spend kind of the last few years of his employment down in Florida working remotely for his employer. That's something that we think employers need to be aware of, because different states treat what's called the nexus test differently. And so as we indicate here, the physical presence of employees in states where, the company might not be based could have implications on, how the company's revenues are treated for tax purposes, how the individual's revenue is treated, what state does he report to or he or she report to. And so as we indicate here, even a single telecommuting employee can create a nexus for tax purposes. And so, what does a nexus for tax purposes mean? Well, typically taxes are addressed based on the physical presence of employees in a state. And so the state where the individual is physically located typically has jurisdiction for purposes of the company's income taxes, franchise taxes, sales and use taxes, and so on. And so, as we're looking at these new work arrangements, unbeknownst to an employer, perhaps an individual has moved to a vacation home. Let's say they were already a remote employee who worked from their home in their home state, but they moved to a vacation property. Functionally, it's no different, working from there versus working from their home state. But unbeknownst to the employer, this could, cause some tax issues for that company if they weren't already availing themselves of that state for purposes of generating revenue. During the pandemic, based on research that I've done, there were some states that provided some temporary suspensions of these nexus thresholds, and apparently, or at least based on what I've been able to see, the majority of those have been lifted. However, states are still adjusting based on what everyone is seeing as a growing remote workforce. And so, just for example, looking at California, which is a state where they had significant lockdowns and executive orders related to staying at home. California did not treat an out-of-state corporation as availing itself of the state simply because of the presence of an employee who was teleworking from the state. And so that did not impact that company's tax burden or tax requirements with respect to California. And fortunately, California put out some fairly detailed guidance on how to treat those situations. For those of us in Michigan, this is a closer example, but the state of Michigan did not waive the nexus requirement due to virus-related telecommuting. So, essentially the guidance was if a Michigan resident was working remotely for a company out of state and that state taxed the wages, then Michigan would give that resident a credit against their tax. And so, these are just a few examples, but the overarching point is when we're looking at how we're treating our employees and if we're accommodating requests to work remotely, we need to be aware of where they're actually working when they are remote. And we'll get into that later when we talk about, some recommendations that we have for best practices. But, establishing an understanding between the employer and the employee of where the employees are and, where they're working and when they're working certainly is best practice as we see it. Next slide, please, John. Thank you. Another issue that most likely was not on the forefront of our minds as we're all figuring out how to keep our businesses going is, how do remote work considerations impact workers' compensation, potential injuries at work, and things of that nature. So studies show that before the pandemic, the most common workers' compensation claims that were filed by telecommuters related to repetitive use injuries, such as carpal tunnel or arthritis related issues, slip and falls, and then mental health issues. Since the pandemic has happened, we're seeing an increase in the new or worsening wrist, shoulder, and back pain claims by employees. And what's very interesting is we're seeing a higher increase in those complaints by the younger workforce, the ages 20 to 35 age range, according to one survey. Based on another interesting statistic that we found was that one of the most predominant causes of injury, according to the National Council on Compensation Insurance, was slip and fall, which apparently account for about 40% of claims related to lost time. Now that we're seeing a growing number of individuals working remotely, we're seeing an amplification of these already existing trends before the pandemic. And so as employers, we need to be aware that these issues exist and that they are likely to increase both in frequency and in magnitude. And so one of the recommendations that we have is any consideration that we had related to the workplace before the pandemic is something that we need to consider when we're looking at employees' remote work environments. And so, there's a lot of focus in offices about ergonomics, making sure that people have proper posture, that they have comfortable chairs, that they have, sizable desks so they're not hunching over. And during the pandemic, unfortunately, a lot of people worked from their beds, they worked from their kitchen tables, they worked from their couches wherever they could just to get by. Now that we're moving toward a permanent home work environment, this is something that we need to consider. Additionally, as it relates to these workers' compensation claims, we're also seeing that there are new hazards or unanticipated hazards that need to be taken into consideration, such as computer cords, poorly placed furniture, makeshift office arrangements. Thank you, John. So this lends to our next topic, which is, how do we deal with equipment and supplies? And so I'm sure most of you, early in the pandemic were most likely either transitioning current furniture and equipment to individuals' homes or engaging in some sort of reimbursement policy for equipment that individuals had to buy to be able to effectively work from home. And so, now that there's this either, abundance of furniture and equipment, or, we need to address how individuals are going to either maintain that equipment or return it to the employer when they return to work. This is something that we're seeing with some of our clients. And so, for those who are considering making these arrangements permanent, we need to address whether individuals have adequate permanent work from home environments. And so this can either be accomplished through, loaning out equipment, as we discussed earlier, or, some sort of reimbursement policy. But overall, this is something that we should be considering and should be documenting as well, just so, it's organized and we're aware of what is out there and who has it. Looking at our last bullet point there, just as we would with any pre-pandemic policies related to company equipment such as laptops, cell phones, badges, anything that an individual would use like that before the pandemic, we'll also need to modify those policies so that we're, keeping track of this property, because it is valuable and it's the company's to address and to deal with. And so updating those policies to reflect a change in, physical property that may be held remotely is something that we would recommend everyone take a look at. Next slide, please. Finally, for this section of the presentation, I'm going to address equity considerations, and this is something that we're seeing more and more as these arrangements become permanent. And so one thing that we've seen based on some studies is that less than 50% of workers had dedicated home offices from which they could work during the pandemic. And so, we need to make sure that, we're providing equal opportunities for our staff to work, but also, B, we need to make sure that, if they do work remotely, these individuals have the necessary equipment to fully perform their job functions remotely. So, what we're recommending is that companies assess each position and determine what positions can reasonably be performed remotely, and to categorize those positions so it's fully documented, and if there are requests for accommodation, that those positions are identified either as capable of remote work or not. What we've seen lately, I believe this was in the fall of last year, the EEOC filed its first case on behalf of a charging party related to a claim for failure to accommodate. Just the general facts of that case were that the individual had some respiratory issues that caused concern, and at the start of the pandemic, that individual requested an accommodation to work from home a couple of days a week to minimize her exposure to other individuals. Fast forward a little bit in the pandemic, and that individual, along with all employees, were transitioned to a more permanent work from home situation where I believe it was 4 days a week they were working from home. And so once that policy was lifted and everyone was required to come back to the office, the individual renewed her request for accommodation. It was denied, and subsequently the individual was terminated for performance issues. But the long and short is the individual brought a charge to the EEOC, which then filed a lawsuit on her behalf and argued, or is at least asserting that the failure to accommodate was a violation of the ADA, and we're starting to see more of these claims that call into question whether remote work is an undue burden or expense on the employer. And these are some fairly crafty arguments by the plaintiff's bar that during the pandemic it wasn't an undue hardship because everyone was capable of working remotely. Of course, on the contrary, you could argue that the pandemic was an unprecedented situation, and just because this accommodation was made during the pandemic does not mean that it's not an undue hardship now. So that's something that we're keeping an eye on. We also think that, or we can also anticipate that there may be additional claims related to age discrimination, race, sex, other protected characteristics, which could be based on different work from home arrangements. So that's something that we need to be aware of. Additional equity considerations that we need to be aware of and keep an eye on would be making sure that all employees have access to the same equipment. If they are working from home, making sure that we're addressing their internet phone service, making sure they have webcams and laptops, so we're not limiting the access to remote work to those that have sufficient resources, because certainly any different or disparate treatment of an employee in the the benefits or the services of their employment certainly could be the basis for discrimination complaints. So long and short, let's I guess one of our recommendations would be, let's look at all of the aspects of individuals' employment, including access to remote work, whether compensation needs to be adjusted, and other fringe benefits. Next slide.
Thanks, John. Next, we're going to talk a little bit about data and equipment security. With this increase in people working from home and remotely from wherever, there's really a growing cybersecurity issue. There have been many more phishing attacks and ransomware attacks, which I'm sure many of you have heard about in the news. Many employers have gone to virtual private networks, VPNs, which are expensive, but they provide secure access to company servers and are a lot more difficult to fall to phishing attacks or ransomware. Probably not impossible, but it's a highly secure way to manage remote workers. You have to take into consideration what data your employees have access to, and maybe you need to limit their access depending on what they do. There are obviously increased costs associated with efforts for better information technology, security types of measures, as well as increased security staff in your IT departments. Tangible costs can be virtual private networks, remote access servers, antivirus, anti-malware, or firewalls. You need to make sure that company information is protected. You need to make sure client information is protected. Depending on the business of your company and the kinds of access that or kinds of data that remote workers are dealing with, you could have requirements under HIPAA or FERPA, the Federal Education Act that protects educational records. HIPAA obviously is the act that protects medical information. And you have to be very conscious that there is enough security to protect the flow of that information to remote workers and from remote workers, because there are significant penalties if there are violations of those types of acts. You have to consider document printing. Is it being printed on a common printer in a place where other people might have access to protected information? How is private or confidential information being disposed of? Are they throwing it in the garbage? Do they have a shredder? Do they bring it back into the office to dispose of? You need to consider that and have a policy regarding those types of issues. You should have a policy regarding device access. Are they allowed to use their personal phone or required to use their personal phone? Are they using personal computers for company work? And if so, how do you make sure the work information stays secure? Are other people using that computer or an iPad or the phone? You need to make sure if they are, well, even if they're using a company-issued device, but especially if they're using a personal device, you need to make sure that there's antivirus software on it, anti-malware tools, that there are firewalls in place, perhaps VPN. These are all concerns that you should consider and work with your IT department and your management to develop policies and procedures to prevent incidents from happening. But then you also need a policy to deal with responding if there is an incident, a disclosure, a phishing, a successful phishing experience that gets into your network, wreaks havoc with your system. You should have people aware of who to contact, how to contact them, and the need for immediate contact if there's anything that goes wrong, so that it can be addressed immediately before it hopefully blows out of proportion. And you should also consider cybersecurity insurance coverage. I've actually had clients that have this and have had to use it, and it was worth every penny to them when they had a breach of data, and the insurance company stepped in and covered not only the IT costs, but also attorney costs and things like that. So it may be well worth your while to check that kind of policy out in this day of remote work. I know that it's out there, and I don't know the specific cost, but I do know I've had a couple clients who've had it and have been very grateful and thought it was worth every penny. that they spent on it. From 2016 to 2020, the number of policies nearly doubled, so a lot of people are checking this out. The average cost of a cyber breach is $4.24 million. So this is why it's worthwhile to check out the insurance, as I'm sure you can see and do the math. Premiums are growing significantly, but again, when you look at the average cost of $4 million, it still may be worth it to pay the premiums to have coverage. And in my experience, the coverage, the insurance companies were willing to work with the specific employers to change some of the policy language to specifically meet their needs. And where they wouldn't, the clients were able to put language in their contracts to meet the needs of the insurance policy. So if there were breaches, it would fall under the coverage. So those are considerations if you're going to go that route. Remote employees and employers, what does this mean for you? Be serious about security, develop and follow documented protocols, be vigilant, and everybody needs to treat the remote office like a formal office. Thanks. Next slide. Our next topic is performance management. Employers have to be transparent about using productivity monitoring software or other efforts. Don't do it secretly. Tell people, look, we can tell when you're working at home and when you're not. So just be honest. If you're not working, then log off and, check. Don't put that time on your timesheet. There are automatic ways to do this versus manual tracking. There are privacy concerns when you have remote workers. It's hard sometimes to put a line between work and home life. It kind of blends together, and I think everybody is willing to give their remote workers some leeway, but a lot of employers are sensitive to employees who seem to take advantage of that. If you're going to have a policy, if you're going to do it, you should have a policy, at least internal. You don't necessarily have to disseminate it to your employees, but to avoid discriminatory or discrimination type claims, you should have a policy of what you're going to do and how you're going to do it. So are you going to track your employees only while they're logged into the computer? You should disable tracking during documented breaks or not. You have to have consideration of exempt versus non-exempt employees. Definitely, if you have non-exempt employees, these are bigger considerations, because even if they're supposed to work a set schedule and not supposed to work overtime, if they're working more time than allowed during the workday, you're still going to have to pay them. John is going to address that a little later, I think. Another concern, and this was a little bit stunning to me, but there's been a lot of information out there lately that many employees are actually working 2 full-time jobs while they're working remotely. They have their regular job that sent them home remotely, and then they pick up another job and are juggling both of them and essentially working 2 full-time jobs, and neither employer knows that. So you would want to consider in your policy to prohibit moonlighting, and if they have a second job, that they have to disclose it to you so that you can, determine whether they're actually even able to work full-time for you if that's what their job is. So institute a policy prohibiting moonlighting or using company time and resources for outside work. Some issues to consider are conflicts of interest, negative impact on productivity, performance, attendance, use of company resources. Again, you have to consider Fair Labor Standard Act violations for non-exempt employees. For exempt, that's not a concern, but it's a huge concern with non-exempt employees, especially those that are newly remote, that didn't always work remote and don't necessarily understand the implications of just, waiting to put the kids to bed and then getting on their phone or their email and finishing up some tasks for the day. And your policy should also clearly define the consequences for violation. Are they going to be required to come back into the office and no longer able to work remotely? How do you handle that? And so take those into consideration, but include those types of issues in any policy or procedure that you create for remote work. And I guess I skipped right over the fact that you need to have a policy. I'm just assuming everyone has by this point discovered that if you're going to have people working remotely, you need some policies and procedures in writing in place. And now I'm going to turn it back over to John to finish out our morning. Thanks.
Thanks, Laura. So yeah, as Laura touched on, one of the main issues with tracking performance and managing performance of your remote staff is, for those who are not exempt from the FLSA, that this can have a significant impact on the employer as it relates to overtime. So, as everyone on this call is aware, the Fair Labor Standards Act requires that all non-exempt employees be paid for all hours that they work in a work week and that they be paid overtime for hours over 40 in that work week. The Fair Labor Standards Act requires employers to track and record hours worked by non-exempt employees. And so, what does this mean for remote staff? Well, first of all, we all have certainly put into place policies related to tracking time. But if we're using software to track time, we need to make sure that we define, what the workday is, when does it begin, when does it end, and establish that employees, are required to clock in or clock out using a specific measure on their computer, so we don't get into any unanticipated FLSA issues, whether that be, paying for overtime that wasn't approved, or getting into, even worse, claims that we didn't, compensate non-exempt employees for all of their time. Another issue that could come up, and this would need to be addressed on a case-by-case basis, but what if a remote employee forgets to clock out, leaves the house, goes and runs errands, comes back, and they've been clocked in this entire time. What's the disclosure process? It needs to be clearly defined in policies so that those issues aren't unanticipated and that they can be addressed appropriately. As we touched on with, understanding where your staff are and, when they're going to be working, that flows right into this topic, which, we need to have an understanding of where our staff are when they're working, even if they are remote, and so, what we'll touch on to wrap this up is, remote work agreements and, defining a number of these things. But for our remote staff, we would recommend that you have specific contact information, how are individuals to be contacted during certain parts of the day, what's the primary method of contact, what's the secondary method of contact, so that we're able to track our workforce, do the work that we need to do, certainly, but, be assured that individuals are actually working when they say they are. Of course, as Laura touched on, no moonlighting. We need to make sure that individuals are working for us when they're clocked in, that they're not working off the clock because that pulls in FLSA considerations. We also need to make sure that we're diligent with our approval process for overtime, because it's very easy for an individual to unintentionally exceed their hours because the workday does blend into home life. When you're working from home, if you work till 5:30 or 5:36, that could make a difference. Additionally, we could see for states where comp time is permitted that that we could update those policies and likely should, because often parents who work from home are juggling parental duties or maybe running to appointments while they log off. And so being flexible with comp time certainly will have intangible benefits to recruiting and retaining your workforce, but also may be appropriate as we move to a more remote or hybrid work model. And again, as Laura touched on, we need to make sure that these policies clearly define what the consequences are for violations, whether intentional or not. Next slide, please, John. Another issue that maybe we didn't anticipate, similar to taxes or workers' comp issues, is, what does a remote workforce mean for the company from a legal perspective, specifically, related to establishing jurisdiction or resolving conflicts of law. So, when we say jurisdiction, we're obviously meaning jurisdiction for, where would a employer be subject to jurisdiction for purposes of a court action or for implication of certain laws or regulations. And so generally speaking, jurisdiction would be defined as, a company having sufficient minimum contacts with the state such that the employer could be considered to have purposely availed itself of that state. And so, there's a distinction between, if you intentionally recruit out-of-state employees for the purposes of developing or conducting business in that location. For example, if you're, a company that sells software and you want to expand to another state, you're going to hire a salesperson in that state that has, knowledge of that region. At that point, you certainly would be considered to have availed yourself of that state for purposes of jurisdiction. However, if you just have a remote worker in my previous example, let's say, who moves from the Northeast down to Florida to perform their work, but they're still maintaining their business in the Northeast and not really availing itself of Florida for purposes of the company's business, that would not necessarily implicate the company, in terms of jurisdiction for that state. So, if in general, if the reason for the individual living and working in that remote state is for the personal convenience of that individual, then that's not going to establish jurisdiction for the company. Of course, all of these considerations need to be addressed on a case-by-case basis. So, this just further highlights why it's important to know where your employees are, when they're working, how often, so on and so forth. Some other implications or I guess effects of how jurisdiction or conflicts of law could impact a business based on remote workforce are, the unanticipated consequences like which laws apply. So, here in Michigan, we have the Fringe Benefits and Payment of Wages Act, which, requires individuals to be paid their fringe benefits when certain fringe benefits when they separate employment, unless, a policy establishes that you're not entitled to, let's say vacation time if you're fired for cause. And so if that's clearly laid out in the policy, then that individual, their entitlement would be determined based on Michigan law and that specific act. However, if that individual has relocated to another state, then the question becomes: does that state have jurisdiction over the company and over that employee as it relates to payment of fringe benefits upon separation? So, a number of other potential impacts based on jurisdiction would be, what state's payroll practices apply? How often are you required to, pay out, or how are you required to make your payments? Do you have to pay by paycheck? Can you do electronic payments? What anti-discrimination laws apply? What leave laws apply? As states are instituting and passing more mandatory leave laws for employees, certainly that could impact the company if they move, or if an employee moves from a less liberal state to a more liberal state, and potentially exposes the company to that state's leave laws. So these are just a number of issues that we think you need to at least be aware of as you're approaching this new phase of hopefully the endemic and no longer the pandemic, and as we address our work staff. So, what does all this mean? And kind of closing thoughts from us. Best practices that we were seeing and what we're recommending is that, we need to clearly define the work arrangements with our staff. What was okay during the pandemic as we were just trying to, get by is no longer necessarily going to be, our permanent work environment. And so, we think everyone should perform a comprehensive analysis of their staff to see, what positions are appropriate for remote work. And if we do provide remote work, provide the employees with an opportunity to either make an election whether they want to be remote, in the office, or hybrid. And if the remote work is approved, then we would recommend that we establish the employee schedule, clearly define it, and outline the expectations for that employee. And so what we're seeing and what we're recommending is that companies have their individuals who do work remotely, whether fully or in a hybrid model, to sign very specific remote work agreements. Our policies were reactive. These remote work agreements are an opportunity for us to be proactive. And we need to formalize these agreements based on each employee's circumstances. And so, what are some of the topics that we're addressing with these agreements? Times, days, locations of work. What are the individual's responsibilities? Next slide, please. How is the company and how are colleagues going to communicate with remote staff? Are remote workplaces safe, ergonomically sound, and are there designated places for individuals to work? Or are we, are individuals going to continue working from their kitchen counter? Certainly not ideal. As Laura touched on, a number of information and privacy concerns. So we need to make sure that our policies are followed and that the work agreements clearly establish those so that we can ensure that our clients, have security with their information and their data. What furniture, equipment, or supplies need to be, provided so individuals have proper remote work environments. What are the different taxing and zoning regulations that we have to adhere to for different individuals who work remotely. As Laura touched on, ensuring that individuals are working for us when they're saying they're working for us and that they're not moonlighting or otherwise engaging in other work while on the clock or utilizing company equipment to work for other companies. So these are just a number of considerations, but in general, this is an opportunity for us to define these new workplace remote arrangements and certainly being proactive and spelling out the expectations and the consequences we see as a best practice at this point.
Well, thank you very much, John. Laura, great job covering a lot of information. We have whipped right through our hour of content, so thank you for that. Time has come now for questions and answers, and we hope that you have some. I know that I see one in the questions queue already, so I'll go ahead and ask this one for you. And I'll remind everybody before I do that to just type in your question in the questions queue area of your display. So please do that now. The question that is in the queue is, have you seen employee requests for reimbursement of utilities such as electricity or internet?
I have not. I think it's fair to just deny that. I don't think you have any obligation to. I mean, if they want to come in, if you're prohibiting them from coming to work, it's one thing. But if they have the option to come into work, but they choose to work remotely and you choose to allow it, I don't think it's something you would have to do. If you want to, of course, you can always do more than you have to. But if it's their option to work remotely, then I think that that's an expense that they can bear.
Okay. One of the questions that I see is a general one. It says, what are some of the common questions you receive from clients about employees working remotely or on a hybrid basis? So what are the most common questions?
Well, I think, this has kind of died down lately as a result of, the Supreme Court decision and some of the challenges to the OSHA, mandate. But, what can private employers require by way of vaccines, by way of testing? And so, that's a pretty fluid situation, which Laura touched on. But, as she indicated, certainly private employers can mandate to the extent they feel comfortable, and but at this point, it seems like with the competitive nature of the labor market, that's something that we're seeing less and less from our clients now. Excuse me, from our clients.
Great, thank you. Okay, just a reminder, type in your questions now. We have two more to cover here, and we'll wrap up unless I see more in the queue. What do you do when your CEO decides everyone needs to return to work, but the employees don't necessarily want to do it?
Laura, do you want to take that one?
Yeah. It's, it puts HR between a rock and a hard place, and I actually get this a lot. I think your arguments to your management that are trying to require this are, if the person is successfully working from home, it makes you a more flexible employer in the workplace and in the community to allow at least a hybrid situation. And what I'm finding is in the places where there's a hard and fast rule not allowing remote workers, they're getting a ton of reasonable accommodation requests, whether they're legit or not, that everybody's expending time on trying to figure out if they have to accommodate people by allowing them to work remotely. And it's if they're successful at it, it just makes a lot of sense. And it also, depending on how you provide supplies and things, it may be a lower overhead cost to allow people to work remotely. Right now, employers are pretty well trapped into leases in most cases, but going forward, they're going to be able to downsize office space and significantly reduce rent expenses in some cases by allowing remote workers. So there's financial benefits to it. There's goodwill attached to it. But ultimately, it is the employer's decision. And if it's a hard and fast rule, you can make everybody come into the office, but you'd have to also allow for medical or I don't think there are too many religious exemptions that would require you to allow remote working, although I've had some Head Start programs that people have gotten religious exemptions and they can work remotely, and so it does end up being an accommodation for a religious exemption. But in most cases, I think if you're not subject to a mandatory vaccine mandate, it probably wouldn't come into play. But with regard to medical exemptions that rise to the level of a disability, you just might have to do it anyway. And on that topic, not all medical exemptions from vaccines are due to disabilities. So that's something to keep in mind, that there might not be a requirement to accommodate under the ADA, even if someone has a medical exemption, but they're all fact specific, but just be aware of that.
Yeah. And if I could just piggyback on that a little bit, as we're, considering these, mandates to return to the office, some of the considerations that, may need to be addressed proactively, with respect to, anticipated ADA requests for accommodations, as Laura touched on, would be, how has the remote work setup impacted the business? Is it less, from a financial standpoint, certainly undue hardship, plays into whether they're, whether these accommodations would cause financial difficulty to the employer, but also, is it unduly extensive? Is it disruptive to the workforce to have individuals working remotely? So, just addressing those factors and looking at every request on an individual basis, certainly if you do your due diligence and are prepared to address those requests, it would help to have examples, whether, financial or otherwise, just to be prepared for those requests.
Okay. Accommodations is certainly on the minds of our attendees. We have one last question, and I'll just mention this one more time. If you do have a question, now is the time to add it, because we are down to the end. If we bring back all employees, but some have requests for reasonable accommodations, or there are already established reasonable accommodations, can we allow those folks to work remotely?
Yes.
Well, that was easy.
Yeah, if you have a disability that requires reasonable accommodation and working, then yeah, you can and you should.
Great. Okay. Well, I don't see any other questions in the queue right now, so I'm going to go ahead and start wrapping things up. If I see anything, I'll let you know, and we'll take it up with you then. So just as we get toward the end, I like to mention a couple quick items. At the conclusion of our program, you'll see a pop-up survey, so we would really appreciate it if you take a moment to complete that. We love to get your ideas for future webinars in particular, so please be sure to indicate in your response if you'd like us to address anything in particular. The other thing I always like to do is remind everybody that our recording will be on this event, on the event page of our website, plunkettcooney.com is where you can find it. You go to Insights, and then we have our event page. Look for this program, and you'll see the links there. Feel free to steer colleagues towards these resources as well. We also put up the slides in PDF format so you can have those and share those in your organization. And then I also like to give a quick plug to our attorneys who put a lot of time and effort into our sophisticated employer blog. We have got a number of years worth of content out there for you, a lot of great stuff to check out. So we would invite you to also go to our insights page and look for blogs. Our sophisticated employer blog is something you can actually subscribe to just by including your email, and you'll get notifications of new content. So we love to have you join us there. So on behalf of Laura and John, I want to thank everybody for joining us today. We hope you found today's program to be informative and useful. So we're always here for you. So if you need to contact us, please do. And on that note, we will wrap up, and I wish everyone a great rest of the day. Thanks so much for joining us.
Thanks, everybody.
Thank you.